So the original FISA statute stated that if the government wants to collect an American's communications for intelligence purposes, the government must go to a court, show evidence that the American is a terrorist or a spy, and get an individual warrant. This upheld the same principle that the Founding Fathers fought for in the Revolution. It's the same principle enshrined in the Bill of Rights, and it said that government officials are not allowed to invade Americans' privacy unless they have specific evidence and an individual warrant. Now, after 9/11, Mr. President, the Bush administration decided that it would seek additional surveillance authorities beyond what was in the original Foreign Intelligence Surveillance Act statute. Now, to our great regret, instead of asking the Congress to change the law, the Bush administration developed a warrantless wiretapping program. Let me repeat that, Mr. President. A warrantless wiretapping program that operated in secret for a number of years. When this became public, Mr. President, as I've said on this floor before, these matters always do become public at some point. When it became clear that the Bush administration had developed this warrantless wiretapping program, there was a huge uproar across the land. I remember how angry many of my constituents were when they learned about the warrantless wiretapping program. And I and a lot of other senators were very angry as well. Mr. President, like you, I have been on the Intelligence Committee, and I've been a member for 12 years, but the first time I heard about the warrantless wiretapping program, the first time I heard about it was when I read about it in the newspaper. It was in the New York Times before I, as a member of the Senate Select Committee on Intelligence, knew about it. There was a very heated debate. Congress passed the FISA Amendments Act of 2008, and that was to replace the warrantless wiretapping program with new authorities for the government to collect the phone calls and emails of those believed to be foreigners outside the United States. Now, the centerpiece of the FISA Amendments Act, Mr. President, is a provision that is now Section 702 of the FISA statute. Section 702 is the provision that gave the government new authorities to collect the communications of people who are believed to be foreigners outside the United States. And this was different than the original FISA statute. Unlike the traditional FISA authorities, and unlike law enforcement wiretapping authorities, Section 702 of the FISA Amendments Act does not involve obtaining individual warrants. Instead, it allows the government to get what's called a programmatic warrant, lasts for an entire year, and authorizes the government to collect a potentially large number of phone calls and emails with no requirement that the senders or recipients be connected to terrorism, espionage, the threats that we are concerned about. If that sounds familiar, it certainly should. General warrants that allowed government officials to decide whose privacy to invade were the exact sort of abuse that the American colonists protested over and led the Founding Fathers to adopt the Fourth Amendment in the first place. For this reason, Mr. President, Section 702 of the FISA law contains language that is specifically intended to limit the government's ability to use these new authorities to spy on Americans. So let me emphasize that, because that is crucial to this discussion and the amendments that will be offered. It is never okay for government officials to use a general warrant to deliberately invade the privacy of a law-abiding American. It was not okay for constables and customs officials to do it in colonial days, and it is not okay for the National Security Agency to do it today. So if the government is going to use general warrants to collect people's phone calls and emails, it is extremely important to ensure that this authority is only used against foreigners overseas and not against law-abiding Americans. Now, despite what the presiding officer and the Senate may have heard, this law doesn't actually prohibit the government from collecting Americans' phone calls and emails without a warrant. The FISA Amendments Act states, and I want to quote here because there's been a lot of inaccuracies and misrepresentations on this. The FISA Amendments Act states that acquisitions made under Section 702 may not, quote, intentionally target a specific American and may not, quote, intentionally acquire communications that are known at the time of acquisition to be wholly domestic. But, Mr. President, the problem with that is it still leaves a lot of room for circumstances under which Americans' phone calls and emails, including purely domestic phone calls and emails, could be swept up and reviewed without a warrant. This can happen if the government didn't know that someone is American, or if the government made a technical error, or if the American was talking to a foreigner, even if that conversation was entirely legitimate. And I'm not talking, Mr. President, about some hypothetical situation. The FISA court, in response to a concern and I and others have had, the FISA court has already ruled at least once that collection carried out by the government under the FISA Amendments Act violated the Fourth Amendment to the Constitution. Senate rules regarding classified information prevent me from discussing the details of that ruling or how many Americans were affected over what period of time, but this fact alone, Mr. President, clearly demonstrates that the impact of this law on Americans' privacy has been real, and it is not hypothetical. Now, when the Congress passed the FISA Amendments Act 4 years ago, it included an expiration date. The point of the expiration date was to ensure that Congress could review these authorities closely, and the Congress could decide whether protections for Americans' privacy are adequate or whether they need to be modified. So again, you go back to what I've described as the constitutional teeter-totter, Mr. President. Our job, balance the need of the government to collect information, particularly with respect to what can be threats coming from overseas, with the right of individual Americans to be left alone. It is that balance that we are discussing. And if the Congress finds it's unbalanced, the Congress has a responsibility to step up and figure out how to make the appropriate changes in the law to ensure that both security and privacy are being protected simultaneously.